Thanks everyone for joining us from your home offices or wherever you're joining in from. I'm just going to briefly run through what Jen and I are hoping to touch on in the course of our presentation, and then there'll be, I think, plenty of time for questions at the end. We'll lead off with Jen providing a view about the differences between electronic signatures, digital signatures, and our traditional wet ink signing. And we'll then be having working through a series of different documents to have a look at what perhaps can be signed electronically now, what does the law allow, and importantly, what's actually practical, and what is the market allowing to happen in terms of the approach of all of the players, such as the banks. In the course of that, we'll also have a short video session demonstrating some electronic signing processes, and a bit of a discussion about what we can be doing around AML CFT requirements, and questions at the end. So I'll hand over at first instance to Jen.
Thanks, Rowan, and hi everybody. So yeah, the first thing we're going to look at is just definitional, really, in terms of the difference between electronic signatures and digital signatures, and then sort of more traditional signing methods. So digital signatures are really just a form of electronic signatures. So electronic signing can be all sorts of different things. It could be clicking on I accept on a web page. It could be inserting the scan of your signature into a letter, which a number of you would regularly do. It could even just be typing your name into an email. So there's a whole bunch of things that could all count towards being a signature that's electronic. Digital signing is a subset of that, which not only sort of enables you to say you accept or are signing the contract, but it actually also confirms that the copy of the contract is the correct copy, because the signature is effectively encrypted into the document. And so once it's been signed with digital signing using what's called PKI, public key infrastructure encryption, you can't then change either the signature or the document afterwards without that becoming easily apparent. And so that's the key difference to think about when you're thinking about signing, is what levels of security can be built into these systems, and particularly with digital signing. So I think if we now move on to which documents can be signed electronically and which ones can't, and we'll look first at what the law allows. So the first thing that we wanted to touch on in terms of legal requirements is the Contracts and Commercial Law Act, which has replaced the Electronic Transactions Act. It has a number of exceptions which don't get the safe harbors, if you like, that are set out generally around electronic signing. And so a number of the questions that have come through have really been focused on some of these types of documents as well. So if I just highlight some here, which hopefully you can see on the screen, the exclusions include affidavits, statutory declarations, and other documents that are given on oath or affirmation, powers of attorney, and also enduring powers of attorney. And this is an important part to the fact that both are captured there, which we can discuss after. And then wills and codicils and other testamentary instruments. So they've been excluded from the legislation. I did have a conversation today with somebody who has a view that just because something, say affidavits, aren't included within the safe harbors, if you like, of this legislation, doesn't mean that you can't sign them electronically or digitally. That's something that I think probably requires everyone to do their own research and come to their own views on. We can talk a little bit further about that afterwards, but that's the starting point in terms of the legislative provision for what can or can't be signed electronically. Just bear with me for 1 second. Actually, while we're on here, the point about the powers of attorney, this is one of the things which I think has been an issue for the banks. So the banks generally haven't been keen to accept electronic signing of documents. And one of the reasons for that is that often they have within their loan or security documents a power of attorney clause, which effectively will say that if the borrower or the security provider doesn't do something which they've said that they will do, they appoint the bank as being their attorney, and the bank could then basically execute documents or do other things in the name of the security provider or the borrower, and that may include needing to sign deeds and things like that. So I think because they've had those provisions in the documents, whether they regularly would or ever use them, it's been an issue that you can't necessarily have an electronic signing of one of those documents with a power of attorney in it, and then rely on the Electronic Transactions Act or the Contract and Commercial Law Act. So there has been an update on that, and that just recently the government has announced an intention to change that, I think temporarily, to enable a power of attorney within a bank document to be signed electronically. So that may remove one of the issues that perhaps has been holding back the acceptance by banks of documents signed electronically. The other relevant sections of things that we're looking at, we've looked at the Wills Act. And so Section 11 of the Wills Act will be important for those of you that want to sort of understand what options might be available in terms of how wills can be signed. And at this stage, it seems reasonably clear, or pretty certain, in fact, that electronic signing of wills isn't possible under the legislation, the Contract and Commercial Law Act that we just looked at, and also that there are difficulties with remote witnessing of wills. You can see I've searched on the screen here for anything to do with the word presence or a shortened part of that. And so you can see that the witnessing requirements, at least 2 witnesses must be together in the will maker's presence. And so that's going to make it really problematic, both for lawyers that are perhaps looking at how they could help their clients, but even with the extent of the level 4 lockdown for people to be able to get somebody else to be their witness, very challenging. And also, so you would need to actually print a copy of the document and then have 2 people physically there to see you sign it. So that's quite challenging, I think, in the current environment. If we switch to the Protection of Personal and Property Rights Act, which is what covers the enduring powers of attorney, and we search there on the word presence, I think it's perhaps more open that while it's still excluded under the Contract and Commercial Law Act that from the electronic signing provisions, there isn't actually any requirement in here that the witnessing has to be done in the presence of the donor. And you could, I think, form the view that, when you compare that to the Wills Act, that would be a deliberate difference. And also when you look at Section 94A(3) here, they've quite specifically said that the actual signing of the power of attorney by the donor, it must be signed by the donor or by some other person in the presence of the donor. So they've clearly recognised that the person who signs on behalf of the donor has to do so in their presence. But when you get down to the later sections around the witnessing requirements, there's nothing in there at all about needing to actually be in the presence of the donor when doing that. So I think that's a useful start point for considering what might be possible around witnessing of enduring powers of attorney. And then we've also got general sort of questions around deeds and the requirements for witnessing with deeds. And so, again, if we look at Section 9 of the Property Law Act, we can see that the requirements for deeds, you must have witnessing in accordance with subsection 7. But when we get down to subsection 7, there's just nothing in there at all around where that witnessing has to occur. You just have to not be a party to the deed. You must sign the deed, and if you're signing in New Zealand, add these details. So again, I think there are some pretty important differences that you can see in the legislation there that might help to form a view about what you can or can't do, whether electronically and witnessing remotely. Rowan, is there anything else that we need to cover on the legal situation?
I think, Jean, that's probably a helpful starting point. And perhaps if we have a look at the sort of market practices that are developing, and then we can go through some specific examples in terms of the particular documents or circumstances that might arise.
Okay, so if we start with the banks, and so maybe taking a step back, I think a lot of the issues that seem to be coming up and might continue to come up are as much about what the parties to the transaction or the process will require or be willing to accept. And so you can sort of have your own views around what you think the legislation might require or what's permissible. But if there's a significant party to the transaction who has a different view, a more conservative view, then you sort of don't have the ability to just proceed by yourself because they won't accept the documents. And so certainly in a lot of commercial transactions, one of the key determinants of this is banks who are often involved because of the financing aspects of transactions. And so there's probably a little bit of a chicken and egg situation there as well, in that the lawyers probably want to know whether the bank will accept digital or electronic signatures on documents or just scanned copies of documents. And the bank might turn around and say, well, as our lawyers on this transaction, if you tell us that we can, then that's fine, we'll accept it. So there's probably a little lack of clarity between the two parties in terms of how this would be done. But as I said, I think part of the issue for the banks has come from the fact that they do have these power of attorney clauses in their documents, and so they've quite rightly probably received legal advice which would confirm that it's not then covered under the scope of the Contract and Commercial Law Act. So that may be one impediment. I think also there's been a significant amount of custom practice built into loan and security transactions, that generally the banks will require all documents to be signed as if they were deeds, even if they're actually quite simple agreements. And so there's a requirement for the highest levels of formality when perhaps that may not actually be required. And there's probably been some inconsistent approaches as well in terms of whether or not physical copies of documents are actually required either sort of immediately or at all. And I guess the banks there are weighing some of the evidentiary requirements that may come up as well, in terms of if they ever need to enforce, whether there's any difficulties if they've only got electronic copies compared to holding originals. I think in practice there are significant challenges with holding originals, where often they end up getting misplaced, if not completely lost as well. So my sense is that it's already been moving more towards the acceptance of electronic copies of documents, and not the bank not needing to receive the full originals. I'm not 100% sure whether that's evolved to the point where they don't require the solicitor to at least be holding the originals, or if their expectation is still that the solicitor has to hold the originals and then give a certificate to the bank confirming that they do, and providing the electronic copies. That would probably need to be checked with each bank as to where they're at on that. But I do know that the banks are moving as fast as perhaps they can to try and address some of these things, and to try and make it easy, but it's perhaps not quite there yet. There's perhaps a related issue maybe that sort of comes up in terms of the undertakings that are involved as well. And if the banks are requiring original copies of documents, that they may be asking the solicitor to give an undertaking that they'll provide those documents immediately or promptly following settlement. That could be problematic in the current circumstance, where the solicitor may not have the originals and may not easily be able to get them, and perhaps it's out of their control whether the client will actually send the originals to them. So I have heard of that in recent days still being something of an issue. And again, perhaps there being some inconsistencies in the approach, where a bank has originally insisted that they have to have original documents and undertakings. The solicitor will provide them. When pushed on it a bit further, the position flipped to actually not requiring original documents at all, and the undertaking therefore not even being required. So probably just getting some clarity around what the accepted market practice, or the practice at least of each bank in that situation, would go a long way to helping. And Rowan, you've had your own experience recently in terms of some other issues around what the bank requirements might be in certain circumstances.
Yeah, I guess just a recent example of where things are up to on a simple conveyancing transaction, where a declaration's required to access a first home KiwiSaver withdrawal, and level 4 arriving and meaning that the declaration couldn't be taken in the way that it normally would. So like half of the profession, I suspect I fell hungrily upon Paul Collins' opinion, which was really helpful to get some guidance around how we might try to continue to operate within those restrictions. And so we went ahead with the process of taking a declaration remotely using a printed out document and video call and scanning. And the end result was a legible document with a declaration that was taken that noted that it had been taken using the AVL witnessing. So I confidently sent that off to the bank, one of the major banks, and with an email of explanation about the circumstances, and received back a we'll look at it, and then we've sent it to our risk department and they say no, we can't rely on it. And then about 48 hours later, further emails saying yes, look, we've after a bit of backwards and forwards, we've reviewed that, and in fact we think that that's acceptable and we'll rely on it, and the KiwiSaver withdrawal has been approved. So I guess that's an example of practice evolving fairly quickly over the last few days, at least for this particular bank, to the point where they're willing to accept something on Thursday that on Tuesday they weren't willing to accept. And so the advice that that Paul Collins has offered, that's I think that's a really helpful place to be looking when we're trying to deal with those sorts of situations. Jean, you happy with that? Shall we continue on to look at some other areas?
Yep, that would be great. I think we'll cover off perhaps the government side of things now.
I wanted to talk briefly about, there's a lot of questions coming in about affidavits and how those can be taken remotely. My area of practice is primarily family law, and there's been some really helpful communication from the principal family court judge, Judge Moran, setting out the process that should be followed by lawyers who are acting for clients in urgent situations, where the client isn't able to sign an affidavit or isn't able to swear them in front of an independent lawyer or registrar. And the overall picture is the registry staff will accept unsworn documents, even in some circumstances unsigned documents, and refer those to a judge. The Epidemic Preparedness Act 2006 has been amended to give district court judges, of whom family court judge are a subset, the ability to vary the rules of the court when an epidemic notice is in force. The key, I think, will really be in the information that's provided by the lawyer when submitting a document that would normally not be compliant. Judges need enough information so that they can determine the extent to which they can rely on that unsworn document. An example of that would be if you're able to get a paper copy to the client, if the client can print a copy out and sign it and scan that back to the lawyer, that provides one level of certainty from the judge that the client has read and approved that document. If that's not possible, because there are people out there, many people out there, without access to things like printers, then the lawyer needs to be providing a certificate or memorandum that clearly spells out the extent to which the judge should be able to be satisfied that this information has been attested to by the client. And that might include whether the document's been read out to the client, whether the client's reviewed an electronic copy or a paper copy. So I think that's been quite helpful to have that speedy guidance from the principal family court judge, because of course a lot of the circumstances in which affidavits are needing to be taken with the level of urgency are situations involving safety which arise in the family court. I also wanted to touch on the requirements for Land Information New Zealand documents. again, the Registrar General of Land has issued some interim guidelines a few days ago, which specifically address a number of the questions that have been coming in for today's webinar around what we do about the witnessing and identity verification requirements, particularly for authority and instruction forms. And it is clear from the interim guidelines from the Registrar General that client authority and instruction forms can be completed with remote witnessing, provided that the guidelines and standards are observed, and they're clearly spelt out within the interim guideline that's been issued. Now, that interim guideline isn't necessarily the way of the future. It's a document that's been issued by the Registrar General to cover the position with the current situation with COVID-19. Working through that guideline, refers back to the 2018 guidelines, which set out circumstances where it's acceptable to depart from the present in-person witnessing. And that has been where you've known your existing client for more than 12 months and that you hold acceptable photo ID on file. But the interim guidelines do make it clear that practitioners may choose to use AVL even if those preconditions aren't met. But that's provided that practitioners take other reasonable steps to confirm the client's identity. And there are a number of pointers in the guidelines as to how that can be done, which includes the ID protocols from ADLS forms, digital signing, and a number of other processes such as approaching a bank to confirm that the bank holds adequate information to satisfy the lawyer of the client's identity. It's also clear from the guidelines that electronic signatures, as distinct from just remote witnessing, are acceptable, provided that they comply with the CCLA requirements, the Contract and Commercial Law Act requirements. And so the practitioner who is relying on an electronic signing system certainly needs to satisfy themselves that the system that they're using complies with Section 2281 of the CCLA. And the guidelines issued by the Registrar General cite as an example the ADLS Web Forms digital signing service. No doubt there are others, and it's up to each practitioner who's wanting to use electronic signing to make sure that any platform that they're using is going to be compliant. The guidelines do make the very clear point for the avoidance of doubt that cutting and pasting an image of a signature onto a document will not be acceptable under any circumstances. So I think that's been put in there just because of the potential confusion around what constitutes an acceptable electronic signature. Verification of client identity is a separate process from obtaining a signature, and the verification of identity needs to be carried out regardless of whether you're obtaining the signature in person, remotely, or electronically. Some other documents that questions have come in about: relationship property agreements. There's been a long-running debate over whether a lawyer advising and witnessing on a relationship property agreement, which might be a separation agreement or a contracting out agreement or agreement in an estate dispute, can be, whether the witnessing can be done remotely via AVL. Ingrid Squire, my apologies to her if she's listening, but did an excellent short article for the Family Advocate back in 2014, entitled "To Skype or Not to Skype? That is the question," back when Skype was the platform of choice for most people. And she made some really helpful suggestions in there about the sorts of steps that a practitioner might take to increase the chances that their remote witnessing is going to hold water if that was ever the subject to any challenge. I understand that there's a proposal for legislative reform around this, limited to take effect during the period of an epidemic notice, which, if that comes to fruition, will make it clear that AVL is acceptable. My own view, for what it's worth, is that if one of these agreements needs to be done, and if this is the most practical way of doing it, lawyers have to satisfy themselves that they're using best practice. If we do this the right way, then it's likely to be a valid document. And if it was void because the witnessing requirements weren't adequately met, there's also the option of the agreement still being given effect under Section 21H of the Act. So the key thing really is going to be to satisfy yourself that the process that you're following doesn't expose the client to any risk. It's things like making sure that the client's alone at the time that their signature's taken, and that all of the usual standards have been met in terms of the quality of advice that's being given. Enduring powers of attorney, look, I think this is going to be a really important one because a substantial proportion of people who are needing to create enduring powers of attorney are people who might have their own health vulnerabilities, either by virtue of age or other health conditions. And while we're all focused, I think, at the moment on the level 4 restrictions that are limiting what we can all do, the reality for a number of people within the community is likely to be that even once the level 4 restrictions are lifted, there'll be people who still are needing to isolate for reasons of their own health or the health of others. And creating enduring powers of attorney is going to be really important for some of those people. We know from the Contract and Commercial Law Act that enduring powers of attorney don't fall within the class of documents where electronic signatures are permissible under that Act. And I take on board Jean's comment that may merely mean that you can't rely on the safe harbour provisions, but certainly the CCLA doesn't provide a way in to indicate that electronic signatures are appropriate. The issue that I think practitioners will be confronting is whether there are ways of proceeding with remote witnessing and advising to create an enduring power of attorney through, for example, delivery or scanning of documents, witnessing by AVL, and then execution of the appropriate witnessing provisions and certificates after that's been done. Jean's pointed earlier to the requirements of Section 94A, the requirement that the signature is witnessed, but there being no specific reference to that being in the presence of the donor. And so the argument could be made that that leaves the door open to using AVL witnessing in the same way that perhaps could be done for the Section 21 agreements. In many of these cases, the option of just waiting until a face-to-face meeting is possible isn't going to be a good option for the client. So I think when we're considering what can be done, we need to ask ourselves what's the alternative. And as long as the client's advised that the process that's being followed could be the subject of challenge, it's really difficult to see a downside for the client in proceeding if the only barrier to creating an enduring power of attorney is the lawyer's concern around whether the technical witnessing requirements are met. Lawyers should be asking themselves, what's the likelihood of the validity of the document being challenged? And what's the reasoned basis for that, and what can we do to make sure that we follow a process that protects the client's interests as best as possible, as best as we can. The reality will probably be that if the process came under challenge and good steps have been taken to ensure that the lawyer is crystal clear about the client's instructions, the client's capacity, the correct advice has been given, and it's clear what the client wants, even if issue was later taken with that document, if there was subsequent litigation under the Protection of Personal and Property Rights Act, all of those things would be really important in terms of the steps that a family court judge might be asked to take around not only declaring that power of attorney valid or not, but also if a judge had to make any other orders to cover any gaps. And of course, these are the sorts of documents which sometimes need to be created. For example, for someone who's in a hospital ward needing to move into rest home care in circumstances where the rest home has a policy that they won't take people on until enduring powers of attorney are created. So my own view is that if we can do this, we should find ways to do it. But of course, practitioners who are being asked to create these documents and witness them and certify them do need to satisfy themselves that the process that they're following is one that they're comfortable with. Wills. Well, the Wills Act requires in section 11.4 that the two witnesses must be together in the will maker's presence. Does that presence have to be physical, or can it be something else? Well, I'll probably leave it to others to determine that. I have always been of the view that a will is going to require physical signing in the presence of two witnesses. But I think from the perspective of a client needing urgent legal services from a lawyer for a will, the answer is we do what we should always be doing, which is we take the instructions and we take them as clearly as we can. We have to modify how we're doing that in the current conditions, because most of us would be used to be conducting a face-to-face meeting as a way of gathering in the information and explaining things to the client. And we might find doing that remotely clunky. The client might need more looking after to make sure that they really are taking on board the advice that they're being given. But those are the circumstances in which we're working, so we have to find ways to do that. And then we have to promptly draft a will that gives effect to the client's instructions. If that document isn't signed in a way that creates a valid will, following those processes will, in any event, lead to a situation where there is a document appearing to be a will, expressing testamentary intention, and there's a very well-worn path now to validation of wills which might have a technical non-compliance in terms of some of the witnessing requirements. And although some of the cases have done things like validate file notes, really having a will out to the client, communication back from the client confirming that they've read it and that the document does what they want it to do, and some advice back from the lawyer explaining what the witnessing requirements are. If the worst happens, I think the lawyer's still done a pretty good job for the client at that point, because that can then be picked up and a will validated post-death if that's necessary. So we don't have, I think, any sort of formal opinions that have come out for guidance around this particular issue. And I'm certainly not wanting to naysay the idea that there may be options that lead to a valid will that could be followed. But I think in terms of my own practice, promptly drafting the will, making sure the right advice has been given and getting it out to the client is going to be doing the best job that we can for our clients in those circumstances. Looking ahead a little bit to when perhaps level 4 restrictions have been lifted, that may open the door to some other creative ways of complying with the Section 11 requirements. The notion of witnessing through a window where once travel is permitted, but if there are restrictions on face-to-face contact, might it be possible for a client, for example, to drive to a lawyer's office or vice versa, and for a document to be signed with the lawyer or another person witnessing, but not being in one another's space. So those may happen. You may also encounter situations where someone who's vulnerable and elderly might have people coming into their home to provide them with care, some of whom are sometimes willing to act as witnesses, or there may be people within that person's bubble who can act as witnesses if you can get a document to them, or if they can access a printer and print that out. So compliant documents may be able to be produced in that kind of way.
Rowan, I did read a story about lawyers in America meeting clients in car parks and sort of signing the will on the bonnet of a car while watching from a safe distance, and then the will maker retreats and the witnesses approach the car, presumably with gloves and their own pens, and sign in that way. So I'm sure there's when we drop down to a lower level, maybe other options. But I was just going to add a couple of other things. So the UK Law Commission did actually look into their wills legislation and whether or not digital signing or electronic signing was permissible. I think that was only last year. And where they got to was that in presence requirement, using pretty much the same wording. I think they felt that that did mean that it was actually being physically in the same location. I think they got enough submissions on it that indicated that it was at least the subject of quite a bit of doubt. And I think, like we were discussing earlier about sort of, it's not just what you think, it's what others are prepared to accept as well. That, if you're entering into a will and there's a possibility that it could be challenged because it may not have been signed correctly, then unless it's very certain, people are more likely to take the view that it's just too risky to go with that. So I think they're looking at a law change there, perhaps as a general matter rather than just relating to COVID-19 or anything, to perhaps bring their law up to date on that. And I understand that the issues are being looked at in New Zealand in relation to COVID-19, although I don't know the details on that. But there possibly will be some change in the way that this is managed, and that could be just relaxing some of the requirements around witnessing. There's been talk about battlefield wills and things, which I think apply to people in the armed services, where you maybe don't have to observe the strict formalities, or maybe it would enable some form of digital signing. And there are people out there who don't have access to printers, who don't have access to scanners, but do have personal electronic devices and the like. And so, maybe enabling a digital option at least could be a way through for the short term. So I'll be really interested to see what does come out of that, and whether that will enable people to put these documents in place. And the video that we'll show shortly, I think, also will give a pretty good demonstration of some of the sort of the features and enhancements that the digital signing solutions can have that might mitigate or remove some of the concerns people might otherwise have around kind of that verification that who actually signed and when and how, and they do it consensually. So I think that was the other points I just wanted to cover off on the wills as well. So I think, Rowan, are we up to now the video where we've got an example that Rowan and I put together yesterday. We thought we would pre-record it because we actually used Microsoft Teams as the platform for the purposes of doing a video call between Rowan and myself, sort of looking at different ways in which you might be able to work with a client or somebody else to be able to share a document on screen between you to confirm that you're both in agreement over the content of the document, and then look at how you might be able to sign that document and witness the signing of that document remotely using a combination of video call software, maybe with a screen share and the ability to record that session, and also possibly using a digital signing solution to enable the signing and witnessing. So I think unless there's anything else, we can probably run that video for people to watch. What we're going to do now is just to take a look at the practicalities of how we would be able to sign documents remotely. And so we'll look at how you would perhaps go about signing a paper document. And in the example, I would be the client, perhaps, who's signing a document, and Rowan is going to be watching me do that so that he would then be able to say that he had witnessed me signing. So we'll look at how you might be able to do that using Microsoft Teams, and then we'll look at how you might also be able to do it using a digital signing solution. And the one we're going to use here is secured signing, which is also the ADLS signing platform that a lot of you should hopefully be familiar with. But we'll start with the signing of a paper document. And so what we're going to do for that is I'm going to switch over to my phone so that we can have a look at the document before I sign it. The other thing that we could actually do would be to share the screen and to enable a look at the document before it's signed as well, so that we're then comfortable we're signing the same document. So to do that, I can come down to the bar at the bottom of the screen here, and you can see that we've got some options. In the middle there is a share option. I should also point out actually that the 3 dots here, if we open those up, there's more actions. And what I've done is I've already turned on recording, but if you wanted to record the meeting so that you've got a further record of everything that's happened in it, you'd come here and you'd click the option which would say start recording. And so you could record the whole of the session. So I've already done that because I needed to record this video. But now what I can do is I can come in and say I want to share my screen, and I will then choose which screen it is that I want to share, and I will then choose the document that I want to bring up. And so I've got the say a deed of variation of lease, which would be quite a common document at the moment, I would think. And so Rowan and I could actually go over this document, and if there was any changes that were needed, we could have worked on that and confirmed what it was that we were looking to do. And I can scroll all the way through this document, which means that we would have a record on the recorded video session of what was in the document that was agreed. And then we're going to use Microsoft Teams for the next section because it has the ability, when you join the meeting through your phone, to be able to both share your screen on the phone, but also to use the camera. And we found just earlier that didn't seem to be possible using Zoom, which is the other common video platform. And so it may be that there are advantages of using Teams for this. What we found was that the alternative on Zoom was that you would have to hold each piece of paper up to the camera on the laptop, which wasn't very clear and certainly wasn't that user-friendly if needing to do a lot of document or a lot of pages. So if I take over on my phone, so Rowan, are you able to see what I'm showing on my phone there in terms of?
Yeah, I can see the document there, and I can see that it's entitled Deed of Variation of Lease.
Great. What I might do is, Ella, if you want to come over, I've got my able assistant daughter, Ella, is also here. And so if you want to hold the camera there, Ella, and just so it shows the document pages, and what I'll do is I'll just move the pages away, and you keep it nice and clear so we can see each of the pages that's on the document. And I'm going to sign on the last page. So we can see my name there, and I would just sign on there, and I can enter my name. And then, although Ella's here and perhaps could be the witness, we're going to say that Rowan would be witnessing this, but he's now got the video record of me signing this document. And so the next thing would be, how do I get that document to Rowan? And the way I think we could do that would be if I was to change what I'm presenting here, and instead I was to share my screen. So what I've now got here is on my phone, I have an app which you can download called Office Lens. And so it's another Microsoft product. And so if I open up Office Lens, I can now choose to do a capture of the document on that. So what I'm able to do, I've got the document that I just signed, and I can take a photo of that. You can see that the software actually finds the edges of the paper for me as well. I've turned the flash on so that hopefully will take away some of the shadowing. I can click as many times as I need to add another page. So I've got all of the pages that I need for the document. I can go done. And now I have an option on what to do with that. And so I can choose to email that. And I could then email that document straight away to Rowan, and in real time, he would have a copy of the document, which he could then do the witnessing, which is also all caught on the recording. So that might be how you could cover off the signing of a paper document in a sort of a relatively user-friendly way, with a decent amount of rigor in terms of who exactly did what and when, and that it was in fact the same document that had been signed, that was signed as being worked on. So I'll cancel out of that. So that was how we might be able to do it with a traditional pen on paper signing solution. The problems with that might be that firstly, you don't have the ability to print the document. Not everyone will necessarily have access to a printer to be able to do that. And secondly, if there are a lot of parties that are involved, it could be still quite a cumbersome process to be able to manage getting everybody signing and witnessing documents in that way. So another alternative that we wanted to show you is the use of digital signing. And the system that I use regularly for that is Secured Signing, which is an Auckland-based company. They also provide the signing solution that sits in behind the ADLS forms, and it's a proper digital signing solution. So it has the PKI encryption and other features that you really want for a high quality, reliable signing process. So if I bring down the Secured Signing application down into my screen, and I think I need to share my screen again, is that right?
That's right. Yeah, we can't see it at the moment, Gene.
So can you see my screen there?
Yes, we can.
Great. So again, we would have perhaps gone through a session where we've looked at the document on screen, and we've confirmed that it is what the client wants to sign, or what we both want to sign. And so I can come in having logged into the secured signing system, and to start with, we'll use the WeSign process. So I'll click on WeSign, and you can actually send out a whole package of documents in one email. So if you had a whole transaction, you could do all of the documents, and they could all be routed to the right people who would only receive the documents they need to sign, and it could all be done very smoothly in that way. But we're just going to do the one document here to show how it works. So I will just upload a document, and I'll click here, Add Documents. You can get it out of other cloud systems as well. And there's the ability to combine files too, but we're just keeping it simple. I'll add a document. So I've got the document that we were just looking at here, lease amendment. I'll upload that. It takes a second. And so we can see now we've got the document, and it's there, and it's ready to be signed. So if I look through the pages, I can look for sort of where the signing needs to begin. I can see it's on page 4, and the first party is Landlord Co. Let's just say we'll skip that one for now, and we'll say we've got ABC Limited, and I've got both Rowan and I in mind as being the directors there, and so if we both signed, we wouldn't need witnessing. So I can click Add Invitee Signature, and I'll put in the details. Say I'll go first, and I'll add my signature. Let's just drag that. I can put it down there, and then we'll add Rowan. We'll add a new invitee signature. Okay, and so we can add Rowan's signature there as well. And then on the last page, we've got Rowan and I signing individually, which will mean that we'll each need to have a witness as well. So I'm going to add my signature over here, and we can see we've got these options on the screen here for a full signature. We'll put the date and time that I signed. We'll put the name. I won't need a job title actually for this one because I'm signing in my own capacity, but I do want to add a witness, and so I can then put the witness where I want them to sign as well, and then we'll do the same thing for Rowan. Okay, so I'm happy with what I've done to this point. I now click on the next button, And I can see I've got a due date, and this is helpful if we needed reminders for when we needed to sign by. We can set a signing order, but I'll set it so that we both go at the same time. We can check the email addresses are there, and there's other features you can use which I think are really helpful around. I could get a notification on my phone that would enable me to tell that I need to sign, and I could sign on my phone. I can add a second factor authentication, which means that I actually have a code that I'll get on my phone, and I have to sign into that code. So it's not just my email address; it's also the code, and so that really goes a long way towards checking that I am who I say I am. I have to review the document before I sign it, so I can't argue later on that I didn't know what I was signing. I actually have to scroll all the way through the document and spend a minimum amount of time that can be set in the settings for that. And I can also choose this video confirmation option, which would enable me to actually film myself at the time I sign, so it'd be further proof that I am who everybody thinks I am. And we could do the same thing with Rowan. I will perhaps save you, Rowan, that needing to do the SMS notification and the video, and we'll turn off the review as well. So what I can do is if I hit send on this now, it's ready to go. And we'll do my my signing first. So I've got my daughter Ella is also going to watch the signing because she'll be a witness as well. So I will click to view and sign. So you don't need to have an account with secured signing to be able to sign. You need an account to send the documents out, but anyone who's being asked to sign doesn't actually need to have their own account. So I need a code which has come in from secured signing, and that is 331295. So I'll click continue there. So I can see an instruction that there is both a waiting period and a need to scroll through the document before I can sign. So I'll click OK. You can see the time has been set for just 15 seconds for the purposes of the video. I have to scroll through the document so we can see it is the same document that we were expecting that we needed to sign. And we'll click continue. And so it takes me straight to the place where the signing needs to occur, and I can just click to sign. And I need to enter the details of my witness now, which is my trusty assistant Ella. So I'll put in her email address, and we'll put in a name. And because I had a second factor authentication, we also need to put in a mobile number for Ella as well. So we'll just put in mine there, and we'll click OK. Now it's given me the video confirmation capture option. Because I'm recording on a video call, I can't actually use the video option within secured signing at the same time. So that part won't work, but we can rely on the fact we're recording the video through Teams anyway. So I'll opt out of that, which is fine, which will then enable me to sign in the usual way. And that part of things is then complete for me. Now, Rowan, if you wanted to take control and share your screen.
All right, so I've got an email inviting me to click to view and sign and giving me the passcode. I enter
So this is showing the experience of someone who doesn't have an account, and so there's nothing, no need to create one to be able to sign.
So Jean, you'd be talking me through this from the other end of a phone call or video call as the lawyer, and it's brought up the signing requirements, and it asks me to enter my job title.
Yeah, so I think probably you'd put director here if we were doing a like two directors signing without witnessing for a deed. So you would be able to do that. And then if you put Ella's email address as well, so ella@turners.net.nz, you going to be visiting with your witnessing. And then there are options for choosing what your signature will look like. And so you can just have the text, or you could use your mouse to draw your signature, or you could upload like what your signature actually looks like. That part of it doesn't really matter. It's all of the security and the encryption which is built in behind the image that's most important at that point. But you can see there that Rowan's now completed everything that he needs to do as well. And yeah, he can look at the document and see the current status of it in terms of where that's at. There's my signature, which has already gone in. There's Rowan's signature, and further down we're just lacking a bit of witnessing, which is what we can quickly cover off next. So if you're able to stop sharing again there, Rowan, and I'll grab that back. So here we have Ella's inbox with the request for witnessing. So we'll click on that, and you can see Ella's just been asked to view and sign. We've got another code that's just come through on the phone. So that's 069 374. All right, Ella, do you want to come through here and you can do your signing? So click to sign, and there's your names. So everything looked pretty good there. Now we need to enter that code again. So do you want to type the code in? So 069 374, and then click sign. And we'll opt out of that video thing because it's not working while we're doing the video call. Once we've got all of the signing completed, everybody who was a signatory to it will get an email which will have the signed document attached to it. So there's no need to prepare counterparts or to go through that sort of scanning and uploading process that we were just working through before using the Microsoft Lens solution. This takes care of all of that. Everybody gets the document at exactly the same time, and you also get this full document log. And so if I go right down to the very bottom here, you can see every step of the process that's taken place in terms of how this went and who was received what communications at what time, and the fact that they did or they didn't use the video functionality, and the witnessing that occurred, and all of that stuff. So there's a lot of really useful verification that can be brought into the signing process when you use a system like this, which I think takes away perhaps some of the concerns that people might otherwise have around whether digital signing is less secure than signing on paper. I would argue that it's more secure because you've got a lot more transparency exactly who did what and when and how they did it. And plus everybody's going to get a copy of the document. And if you want, a copy of the document can also be returned down to a SharePoint site or some other repository like that, and to other email addresses. So the risks of actually losing something become very minimal in terms of how that works. So there you can see all the signatures, and if I zoom in more, you can see on the signature the exact date and time of signing, for instance. So it's a really, really tight and robust way of being able to look at it. Now, the last thing I just wanted to cover off was there is an even easier way of being able to set documents up for signing once you know how to do it, and that's using what's called smart tag functionality. So what I'll do there quickly is I'll just go open up a document with the smart tags in it. So what we've got here is exactly the same document, but what I've done is I've taken some guidance at Secured Signing Publish, and I've actually added into here the details of who needs to sign for each document. So I actually had Ella down here as the signatory for the landlord, but here's where we've got say myself signing as a director of ABC. And so we've got that I'm signing first. It's a full signature, which is the F. The text link says I'll get a notification on my phone. The V says that I'm going to get the video requirement. Title means I have to enter my job title as part of signing. Review means I have to review the document before I can sign it. SMS means that I have to enter the second factor authentication. And then we've got my name and email address and phone details, which will be used to send it out. And so you can do the same thing for each signatory. And once you understand how that works, it's very easy to be able to put that sort of stuff into the document. It's exceptionally easy to do it if you're using sort of a form of document automation where you can basically every time you enter an execution block or a party, you can put in all of the information that you need for the signing in that way. And so what it means is if I was to come back to secured signing and use smart tags, I'll just show you how that would then work. So this time I would come to the smart tags. I would still go through the option of adding files. This time I'll upload the smart tag document. And so you can see it automatically populates those details that previously we had to go through and drag the signing details down into each place where we wanted it. If you use this functionality, then it's possible to actually set the document up from the time that it's first drafted so that everybody who needs to sign will automatically be included with all of the features that are needed. So there's, for me, I've got all of those options available in terms of what I need to do, whereas for Rowan, I only chose some of them. Now, I won't go through the rest of the signing process, but that's another way in which the digital signing could be made even simpler to use from the user perspective. I've been watching the comments coming through on the sort of the chat feed about that, and so although we'll go through a lot of the other questions shortly, I thought it might be helpful just to sort of cover some of the sections on this, and that perhaps was a general sense that what was shown on the video is some combination of difficult and or expensive, and that people may not have access to all of the technology. So I'll just try and provide a little bit more background information on that, just to see if that helps. So the platform that we used for the video call and sort of recording everything, that was Office 365. And so one of the reasons why I was keen to use that is because so many people either already have it or are moving towards it in terms of just having the software for their own personal PC. It almost comes bundled in when you buy a new computer, and so a lot of people will have access to that range of software, and as a lot of it is all sort of built to work nicely together. So I think there's some comfort you can take from the fact, I suppose, that this isn't some new specific thing that you would need to get just for this purpose. It's stuff that you've probably already got, and particularly if your organization has moved to Office 365 or it's going to, and increasingly I'm sure you will go to it because it's ideal for remote working as well, then you'll have that stuff in the toolkit already. And in terms of how hard it is to learn how to use it, it's actually not that difficult at all. We don't actually use Office 365 ourselves on a day-to-day basis because some of the software that we do use doesn't work on that cloud version just yet. But I got a version of Office 365 just to play around with, so I could sort of see what it could do and what it couldn't. And it costs about $9 a month to be able to use per user. So it's certainly not expensive software to be able to get and to start playing around with. And similarly on secured signing, one of the reasons why I was keen to use that, apart from the fact that they're a New Zealand company, and so there were questions around support and how you get set up and learn it, and what happens if something goes wrong, and having a company based in Auckland certainly has been helpful for me to be able to talk to about different ways you might be able to do things and how things can work. It's also a very affordable system to get started with. So I'm on a base plan that costs $10 a month, and I think I then pay $1.30 per document that I use above 10 per month. So the combination of the two, very inexpensive in terms of being able to get set up. And so what I would suggest is, if you're interested in doing this, that rather than sort of trying it out live with a live client who's remote and you sort of wing it on the first go, is you could play around with this and just try seeing how it works internally, using it with some colleagues, just get a feel for it, and it'll take, I think, some of the fear of like how complex and how difficult some of the stuff is. You pretty much can play around with it as much as you like and run signing process. You're not going to break anything. So if you see a button, click it and see what happens, and perhaps see if you can get comfortable with it. So I just wanted to give some sort of context that it's not necessarily a hard thing to do. There was a question in there around what happens if one party doesn't want to sign, or one party signs digitally and somebody else wants to print and sign. You can actually do that too. So you don't have to finish the process. Obviously, you would lose some of the verification in terms of the party that didn't sign digitally. You wouldn't get all of the data associated with that, but it is possible to send a partially signed or partially digitally signed document to somebody else who could then take it, download it, and sign it in a more traditional way. And overall, you could still achieve the overall outcome. So if somebody doesn't have access to an electronic device, they may be able to do that, although I suspect the issue might be more that if someone doesn't have a printer, this might be the only way they can actually do it in the first instance. I saw a question there around delivery and what's required there. I don't think this necessarily changes anything there, and that once the signing process is completed, delivery is a pretty ethereal sort of concept anyway. But if you need to confirm the delivery, you can still do that outside of the digital signing channel. More comments that it looks like it's hard. There was a comment in here around charging for extra time. My daughter Ella will be pleased to see there's a comment about Ella as well. I think in terms of the time involved, it possibly looks like it took a long time. I think when Rowan and I went through and did those 3 different examples, it took us around half an hour to do the whole thing, and then we edited out some of the stuff. I think if you're looking at a multi-party contract and you were honest about the amount of time that's involved in getting a document finalized and then emailing it out to everybody and then chasing several of them up to make sure they actually sign it and that they've signed it properly, and then getting the scans in and then compiling them and then rescanning them and sending them somewhere and saving them, there's a lot of time that's involved there. So it's not to say that this is necessarily going to take no time, but I think it would be significantly faster to do an electronic process involving a number of people. And who knows if the laws changed around EPAs, for example. I mean, those things take months to get in place because you've got to send it to the donor and the witnessing there, and then it's got to go to the attorney or attorneys and then successor attorneys, and the paperwork can take a long time. So I think it's potentially something that could take a lot of the overall time out. There was yes, I've been reminded to say there will be a recording of the whole session, so you can certainly watch it again and break it down and go through more slowly in terms of exactly how you would do it. And there are obviously people that can help in terms of providing further support if you do want to use it. Did I mention the fact that secured signing is used by ADLS? I'm not sure if I did. So another thing that hopefully might help with familiarity is I haven't used secured signing within the ADLS form, so I can't say exactly how it works, but I believe it would be it's the underlying engine for it, and so you probably will see some familiarity in terms of how the ADLS system works and how this also works. So that may also make it a bit easier. I think that covers most of the questions there. I think that will probably do. We can pick up some other ones afterwards. The other thing I was planning on doing just briefly before we go to the questions is we've discussed, Rowan and I, just briefly anti-money laundering, because I expect it's been an ongoing issue for many lawyers anyway, in terms of how you collect all that information, even in a context where it is possible to collect physical original copies of documents and conduct a lot of the verification requirements. We've talked about how you can sort of easily manage some of those requirements if you're working remotely, and so you're not able to easily see and see the original documents yourselves. where we sort of landed a little bit on that was that there are a number of companies that are offering AML digital checking services, and I think some of the guidance from Lynn's actually on remote transactions links back to those same providers also perhaps being necessary for situations where you need an additional level of enhanced verification of identity there as well. So if it was me and I was sort of looking at all of the things that I might need to change or do differently in a remote environment, I would possibly look to see whether that anti-money laundering aspect is something that could be outsourced, where those parties can use the technology they've got, the integrations they've got with the DIA databases and things like that to do as much of that as possible for you, so you can focus on your risk assessment and the stuff that you still need to do. So that was one area that we were just touching on. And then the last thing I just wanted to show was, while we've been talking, I guess, about some of the client documents that are perhaps the chunkier things or the more important things, I think if you head down this route and you start sort of looking at how you can perhaps automate some of the processes, move to a more digital and paperless way of doing things, there's probably a lot of other opportunities for things that you could then also add in as well. So it's sometimes taking the first step that will unlock 3 or 4 other things that you can do. So the example I just wanted to show, can get control of my mouse again, was some work I've been doing recently with a barrister, David Pawson, and one of the things that we've done with him was just looking at his engagement letters. And so we created a simple form that he can use to fill in the details of the client. You can see on the screen perhaps that we've got the details for myself there, and help if I filled it in properly. And then he's got some options for the most common types of matters. And so if it's a standard hourly rate, it'd be very simple. Drink driving sort of matters, you can ask for different information. Keep it simple. We'll just come back to this. And so if he generates a letter of engagement, he can do that really quickly. I'll just open it up so you can see it. This also, so that's going to be very small. I'll make it bigger. Sorry, bring it down. All the terms and conditions. You can see what we've done here. We've embedded the. That's not helpful. I'll tell you what's happened there. We've applied security onto the Word document, so you can't actually edit any of this, which is stops the client changing it. But down the bottom there, I won't click on it because it'll disappear again. You can see that we've built one of those little smart tags in. So in a very similar way to what we just looked at, every time he does an engagement letter, if he wants to, he could now just pump that up into the digital signing platform, fire it out to the client. They could get it on their email or their phone, and they could sign and return it. And again, he would never lose the engagement letter. He wouldn't have to chase it. It would be automatically chased for him. And so again, that might just take a number of hours out of the beginning of a matter that you could otherwise avoid. So really just wanting to make the point, I suppose, that once you start down this route, you'll probably start to see all sorts of opportunities for how you can start to digitize some of the these paper-based processes that will not be so easy to manage in a remote access paper-based world. Now that was that. Shall we jump now, Rowan, to the questions?
Yeah, we're pretty short on time, so I think if we try to move through some questions at pace, that would be that'd probably be useful for people. The questions that came in advance, there's a question, a client overseas in lockdown who has no access to a witness who is on the occupational list on the ADLS form. Can the practitioner be their witness even though they are not physically next to them? They are present at the same time via digital form. Look, I think that depends to a significant extent on what the document is and who the audience is for it. If we're talking about a Land Information New Zealand document, then we'd be looking back to the interim guidelines that have issued. So I'm not sure that we can answer that in any great detail with that information. Jean, any further comment?
No, not on that one.
Okay, and what are the options, if any, for attesting and witnessing wills and powers of attorney during level 4, and what are the options during level 3? Will it be easier? Well, hopefully, that's right, when restrictions change, there will be some easier options. At the moment, as we indicated before, I think doing our best to get on with preparing documents in terms of clients' instructions will advance things as far as we can, and practitioners can consider whether in appropriate circumstances they can proceed to complete enduring powers of attorney using remote witnessing. A question around the High Court accepting a grant of administration on an intestacy affidavit remotely witnessed, and the comment being that the registrar had said that they'd never heard of an affidavit being sworn electronically, and that new rules are pending but don't come into effect until they're gazetted. And I think in terms of the variation to the rules that's permitted under the Epidemic Preparedness Act, that's going to be happening in circumstances where it's priority areas of work, liberty of the person, personal safety and well-being, and time-critical matters. We shouldn't be expecting that courts will be departing from the rules using that exception for our ordinary work. A question of whether the probate unit will consider accepting scanned email applications for probate or letters of administration during the lockdown period. Electronic filing is apparently possible. Again, in terms of submitting remotely sworn documents to the probate unit, well, at least according to the previous question, that's not going to be accepted until there's a change in the rules. Jean, any comment on any of that? Shall I keep rolling through?
Yeah, actually, the one other thing I was going to mention before was in terms of how easy or hard this might be. There are some other services that I believe are either currently or about to, I think basically currently offering support in this area. So Steve Keel's got a business called remotelegalnz.com, and there's a CODA platform. And so I think if you're worried about how you might do some of this stuff, possibly also look at how they're doing things, because I believe they're addressing some of these kind of practical issues as well, and they've got different approaches for how they're doing it. And it's probably not for Rowan or I to go into the detail of how they're doing that sort of stuff, but definitely worth talking to them about what they may be able to do and how comfortable you are with that approach in terms of what you believe that acceptable requirements are, or what's going to be accepted by the people that need to rely on the documents.
A question, if we have to witness statutory declarations, do we need to return a countersigned declaration, or is returning a certificate in its place sufficient? Certainly, the only declaration I've dealt with remotely, we did end up with a document that had scanned copies of wet ink signatures from both the declarant and the lawyer taking the declaration. So that's how we've chosen to do it. I'm not aware that putting a certificate in place of the lawyer's signature would be acceptable. I can't express a conclusive view on it, but that's not the way that we've done it. Jean?
Yeah, it's going to come back to what the person who's it's ultimately got to be accepted by will take, doesn't it?
A question around, we've had a number of questions actually around, which perhaps we should jump to in case we run out of time. Is it possible to certify copies of original documents remotely, for example, a copy of a passport? I certainly haven't. My view is that the standard certification that we're used to giving is a certification that we have cited the original document and that the copy is a true copy of that original. If a certification was to be given on the basis of seeing a document remotely, for example, seeing a video image of a document during a Skype or Zoom call, then certainly that certification would need to be modified to make it absolutely clear to anyone who was asked to rely on it the process that had been followed. I think if we were to simply certify that it was a true and correct copy of the original without specifying that the lawyer hasn't seen and been able to inspect fully the original document, that there's a real risk of misleading whoever subsequently relies on the certification. So it's going to be a question of why is the document being certified, who has to be satisfied with the certification that's being given, and making sure that the certification doesn't exceed what we're actually able to give an assurance about. Some questions arising from Paul Collins' opinion, which Jean and I may or may not be qualified to comment on, but I'll run through them. How is remote witnessing supposed to work if the deponent does not have a printer or scanner? Well, I think the sort of remote witnessing of the kind that I've been describing, involving a wet ink signature, etc., simply isn't going to work if the deponent doesn't have access to a printer or scanner. What I would say on the scanner front is that there are various free apps that are available for the smartphones that most people these days will have, and have access to the App Store or the equivalent, which can be downloaded for free, and which are certainly a pretty big step up on simply taking a photo of a document. So we were able to successfully do that in terms of the KiwiSaver declaration that I referred to earlier. But if you can't print the document in the first place, or get a printed copy of the document of the client, you're pretty much stuck, I think, unless it's something that's amenable to electronic signature of the kind that Jean's been talking about. Next question in the same chain: can this method be used for affidavits that are prepared now but won't be filed until after the lockdown ends? I think the answer is probably no. If we're asking judges to vary rules of the court on the basis of the epidemic notice, then we should probably only be doing that to the extent that it is sufficiently urgent that it needs to happen now. But practitioners would need to take their own view. And I'm mindful, of course, of the fact that, as I said before, we're all pretty focused on when's the lockdown going to end. But if we're then down at level 3 or level 2, there's still going to be some restrictions around face-to-face contact, and some of those restrictions may apply more to some clients than others, depending on their health status. Can the witnessing lawyer sign the affidavit and exhibit notes electronically as PDFs, emailed by the deponent, and then email the signed affidavit to the originating lawyer or deponent? Well, again, it's going to depend on the audience. We talked earlier about the family court accepting documents that perhaps aren't even signed, with an explanation from the lawyer about what steps have been taken. I suspect if we're talking here about an affidavit being taken with remote witnessing and the jurat being signed by a lawyer, then that lawyer would also be signing the exhibit notes in the conventional way. It's difficult to see why we wouldn't follow that process as closely as we can, because we don't want to be asking the court to depart from the rules to a greater extent than we have to. There's further questions here. Does everyone have to sign the same original and hard copy and send it every step by courier? I mean, again, I think it depends on the circumstances and who's being asked to rely on it, what the urgency is, and you're going to be covering off in a certificate or covering memorandum what steps have been taken or why. A question: if my client doesn't have a printer, and if the client agrees, can I email it to their local pharmacist to print, and for the client to pick up from there, since the pharmacy is an essential service? I won't pretend to be an expert on the COVID-19 response, but I'm pretty sure that the going to the pharmacist for an essential service is to collect your medication, not to use their printer. So I'll hazard a no to that. Jean, any particular questions you're seeing coming through that you'd like to respond to?
No, I think we've covered a lot of them. I mean, again, there's more stuff coming through, just highlighting issues around that not everybody has access to the digital sort of devices and things to be able to do this. I would probably just say, look, it's got to be horses for courses, in the sense of like, just because you could sign things digitally doesn't mean necessarily that everything should be. Some clients won't have the devices, some people won't be capable of using the devices. I think there was questions raised around duress. Obviously, if you have any sense at all that it's being done for any reason other than convenience, then you wouldn't proceed with digital signing if you thought that there was duress. So it ultimately still must come back to the lawyer's overall decision as to what's the best way to be able to get this done. I think it's just raising the fact that there probably are alternatives available, that if you're now finding, due to the practicalities of your situation, that what you used to do doesn't work, that you might look at some other alternatives. But it's not to say everything should be done in one particular way. So yeah, there will be an overriding comment to some of the questions that seem to be coming through.
Yeah, the professional duties haven't changed when it comes to ensuring that the client is providing you with their instructions, not acting at someone else's behest. I think Ingrid Squire's Family Advocate article on remote signing of Section 21 agreements has got some specific suggestions around that, ranging from asking the client to confirm that there's no one else in the room with them when they're executing a document, through to having someone else present, which of course isn't helpful, I guess, in terms of the current lockdown. But it's an example, I guess, of how lawyers should be turning their mind to the sort of pitfalls that there might be, and trying to build that into our processes so that we can be confident that we are protecting the client's interests as best we can.
There was a few comments came through asking for examples of specific wording that might be used in certificates or sort of various documents, Rowan. And I guess my thoughts on those would be, I think you've touched on this, describe just as accurately as you can what you've actually done, because I think really the point is just whoever's receiving the document should be as informed as possible about what the process has been, so they can then decide whether or not that's going to be acceptable for them in terms of being able to rely on it. If there are people on the call who are the receivers of the documents, I guess maybe what I could suggest there would be, it would be fantastic if your organisations were able to perhaps publish what it is that you do want to see, or the form that you would like to see, so that perhaps Rowan's example around the KiwiSaver application, it doesn't become something that each individual practitioner has to raise. They could perhaps just do it in the way that you've said will be acceptable. And that might streamline things. So I don't think there's any necessarily one single way of doing it, but it's just a case of trying to be accurate, not ask people to do something beyond what they reasonably can do, and trying to make sure the overall process is working as efficiently for everybody involved as possible.
And I think if we're looking for precedents around certifications that are given, or declarations that are taken, or oaths that are taken, Paul Collins' opinion from the 26th of March had attached to it a draft certificate, and that contains a really useful starting point. But things are going to have to be amended to match the process that the particular lawyer has followed, because I think the most important thing is that any certificate that's given, or any explanation that's given, is adequate to inform the person who's relying on the document of the process that was followed, because that's how we avoid inadvertently misleading anyone.
I think we might be out of time.